Now, these are determinations that I make regularly. We have preliminary examinations in my court every week. And I'll put it in layman's terms. Obviously, as Mr. Gill has indicated, there is a statutory, there's a definition that you look for, and that's certainly what we follow as judges. We have to follow the law. But I'll tell you this, when I was a prosecutor, when we made charging decisions, we looked, and this doesn't happen in every jurisdiction, but we looked for, can I prove this case beyond a reasonable doubt before we charged it? And then we took that case to court, and we made our best case to move the case forward from the district court to the circuit court. Now, when I make the determination as a judge, what needs to happen is you need to fairly and impartially hear the evidence, and you need to make a determination that that scale, which starts evenly, starts to tip. So if it tips in the favor of this is the person who committed this crime and the crime that has been charged was in fact committed, if that scale starts to tip, then you've got your probable cause. At that point, once that scale tips, you send it up to the circuit court and they make further determinations. Often the case is pled from that point on. Sometimes it's tried. But we are the gateway court for all criminal matters, so it's important that we are able to exercise that judgment. In terms of liberal or conservative construction, when they come in front of me, it's a case-by-case basis. There are times when I've had cases already that I felt were very, very close to the line. And when that happens, I give the opportunity to each party to present more evidence, to present better evidence, to present their evidence more clearly, because they have to have the opportunity to do that. And I think that my time is up. So I'll give it to Mr. Janer.
When we're talking probable cause, I think it's easier to talk first on what it's not. It's more than a reasonable suspicion, okay? But it's not more than more likely than not, which is a civil standard. Preliminary examinations are set up in district court to weed out bad cases. Mr. Prosecutor, you don't even have probable cause here, okay? We're not going to send this up and waste our circuit court who's got major things to take care of and let that case go up there, all right? And a lot of times, you know, you'll get a case, and if they say the magic words like, he hit me, or he threatened me with a knife, okay? And then they may meet a threshold of probable cause, but there's still a level of credibility that a judge's responsibility. Is this witness credible? You know, you may find out that the person was drunk or intoxicated or something like that. The key thing for a judge is to understand that role. You are there to sift through and don't send up to circuit court cases that don't belong there, okay? And when you talk about is it a conservative or a liberal construction, I don't think that's, answer is no, it's neither that. It's either probable cause in the judge's assessment or it's not, okay? He doesn't prevent, it's not a defense, it's not a trial stage. It's, have you met a threshold? And that's the key. You've got to meet the threshold. And then if they have, then you send it up into circuit court. And if they haven't, then you don't.
Thank you very much. Okay, the next question, again, we'll have 2 minutes. And it's a general question because many people out in the audience probably are having in their mind some sort of ethical dilemma that many judges face while they're on the benches, and they're wondering how the judges will handle it. So the overall question is, what are some ethical dilemmas that you might face as a judge if elected, and how would you handle those situations? Okay, so we'll start over here first with Judge Barnes. Would you like to start?
I think the ethical dilemmas that you face principally have to do with the relationships that you have with the people who come before you. So if you have already a relationship with a person, for example, my friend Eileen Marshall is right here. If Eileen Marshall were to come in front of me and I were to hear her case, that would be a problem. Ethically, that would be a problem. Similarly, if, for example, you came to my house and you did work on my windows and I was not satisfied with the work that you did, and I have that in the back of my mind, that this is a person who did this job and did not do it well, and then you come before me on a small claim, that would not be an appropriate case for me to hear ethically, because I have a bias. So there are specific rules to follow with respect to disqualification, and we have to be careful about those things, because it's not just about what is actually improper, it's about the appearance of impropriety. You want to be certain as a judge that what you show to the community is every day your very best, and that only happens when you make those determinations. So those, I think, principally are the relationships in a town like this are the ones that most often come to bear in the district court.
I concur with, at this point, with Ms. Barnes, because relationships are key. I think for me, the challenge that I see is running for judge, and I know Mr. Nichols talked about it, not wanting endorsements and people that can contribute to your campaign. Many of them are lawyers and that kind of stuff. What a dilemma that puts you in now that they have their case in front of you. Stuff like that. The good thing is we, as candidates, you can't solicit, or your committee can't solicit from a lawyer any more than $100. Thank goodness, because you know you want to step, you want to be fair, and you want to be impartial, and we're human beings, okay? And those are the I see as ethical challenges here, and you've developed friendships with your legal community, and I know that if elected in November 2nd, my relationship with some of my good friends is going to change. It has to. You can't be judge and be impartial, okay, if your relationships with the certain attorneys are that close, okay? And I have those. Some it's not a problem. I just don't have that type of relationship, okay? And that's my plan. My plan, and it will be that way. I will be fair. And it doesn't matter what you contributed into my campaign, it just won't matter, okay? And if you didn't, that won't matter either to me. And I don't look forward, that's one thing I don't look forward to, that I'm going to have to sever some of that. That relationship is going to change. That's going to be difficult. Thank you.
Thank you very much. Mr. Nichols or Mr. Gill, that's fine. Yep.
I think when Judge Barnes spoke of relationships, that's probably the most common ethical dilemma that a judge has. It's a small community. People come before you whom you have known for many years, some of them superficially, some of them very close. The issues that you have to confront are two. One, how do you actually feel about it? Is this somebody that I know well enough that if I rule against them, I would feel bad? And if that's the case, you have no business hearing that case. But then even beyond that, you have to be concerned as a judge about the appearance, because in cases, appearance is also reality. If the people litigating the case in front of you feel that there's reason to believe you won't be straight with them, that's a bad thing. And we have to understand, judges have to remember we're human beings. If you're elected, you are still a human being, and you have all the weaknesses of a human being. The fact that I'm going to try to be fair with somebody is not good enough. You have to be in a position where you honestly and objectively both feel and are perceived as though you will deal with whatever issue and whatever parties come before the court fairly, without bias, and without a feeling that you wish you didn't have to do that.